Welcome to part 2 of podcast 3 on choosing executors and attorneys. Attorneys are there to deal with the uncertainties of incapacity. It can strike at any time in many different ways. Usually, incapacity doesn't reverse. It can go on for many years, even decades. It can range from an accident suddenly causing total incapacity, the inability to make any decisions or care for oneself, right up to a gradual path into dementia or physical frailty over a number of years. The line, on the one hand, between being fully compos mentis and able to manage your own affairs on the other, being a danger to your own physical and financial well-being, can be a very thick one. Capacity and lucidity are just constructs until they aren't. They can fluctuate, and the point at which incapacity strikes can be a matter of opinion. So who decides whether somebody has become incapacitated sufficiently to invoke powers of attorney? Well, technically, it should be someone competent to do so. The accepted wisdom is that some medical practitioner, ideally it should be one who will know the person already and be able to assess capacity, both in absolute medical terms and on a relative basis, with deteriorating conditions, will be the best person to judge. Such a practitioner will know how the person behaves with a normal state of mind and should be able to decide when the time has come. A medical practitioner completely fresh to the situation could have a lack of understanding of the person's normal state. This is very important. Attorneys could be vulnerable if their appointment could be challenged at some future point, perhaps by a family member, or perhaps even by the supposedly incapacitated person asserting they are indeed capable and the medical practitioner was misled. Given the power attorneys have, the stakes are very high. Perhaps the easiest example to consider in this regard is the one which many families face when they suddenly realise that mum or dad's driving is no longer safe for themselves or other road users. Who decides to take away the keys and deal with the adverse reaction which sometimes follows? It's always best to have attorneys who know the person and can judge the right time to step in. Often, it will be an attorney who initiates the involvement of a professional to do the formal assessment. So in contrast to the situation for executives, where they do not get to choose the time when their appointment becomes effective, attorneys may well do so. This means the choice of attorneys needs not only to reflect people who will make the right judgment calls about starting to act, but also being right for the job when they start to act. Another key contrast is that whereas executors are dealing with the finite transaction of winding up an estate and then being accountable for the outcome, attorneys find themselves in a continual state of exercising judgments and caring for the person's financial and physical health, and they are accountable for as long as they act. They can be making decisions which range from trivial ones of paying the electricity bill or dressing the person, to managing the sale of the family home or deciding on medical treatment in acute or end-of-life situations. Before choosing any attorney, there should be a very full and frank dialogue about the potential scope of the role and the impact it may have on the attorney's own life. No one should be selected or take on the role just because they happen to be a good mate or a close relative, if they're not going to have the time, inclination, and physical geographical location to carry out the duties when needed. Attorneys will be acting severally for most decisions, so it's crucial that they know one another and have the right attitude and approach to mutual consultation and decision-making. Otherwise, conflicting opinions can result in conflicting decisions. There would then need to be redress to the Court of Protection, which is a long, painful and costly process, effectively grinding the attorneys to a halt. The first place people look for either executors or attorneys is usually the family. You'd hope that they would have the person's best interests at heart, but that may not always be the case. Cynical as it may sound, some may have their own interests in scope as well. If a will is properly written, it's hard for an executor to feather its own nest, but in some cases, that can still be possible, especially where property is involved. Attorneys, however, may well be faced with effectively running down the family assets. And key decisions about the person's care can have significant implications for their own legacies. In other words, they may feel they're spending their own money. Integrity and altruism will be very important qualities. The person's children will grow up and should have families of their own by the time the powers of attorney become active. The days of extended families living in the same town are long gone. Family members may be located at long distances. They may have full-time jobs and young families of their own, which make taking on the decision-making and care for the incapacitated person very difficult. Where the person's fairly wealthy, the lives of the attorneys may be easier because there's money to pay for external help, whether in the form of financial advice and administration or physical and medical care. But where finances are limited, attorneys can find themselves juggling between immediate and medium-term decisions on spending money and a view of the longer term where it might even run out. Before someone asks anyone to be an attorney, they should look at that person's current and prospective personal lifestyle and situation. There should also be a full and frank discussion. Most attorneys are just ordinary people, and however well-meaning they may be, they may have given no thought to the issues they'll face. Will they have the time and physical ability to do what's needed, which can change from day to day? Will the burden be too much for them and their families? Will they have the intellectual or emotional capacity to take key financial or medical decisions? Wills and power of attorney should always be kept under review, and the suitability of executors and attorneys considered every time. It's entirely possible that an executor or attorney will die or become incapacitated, which obviously necessitates a change. But there can be less extreme but equally important developments between reviews. A family member living at home may get married, move 10,000 miles away, and start a family. There could be a family rift, and it could become clear that certain members are unlikely to be able to work together. The need for changes in these situations should be fairly obvious and trigger immediate review. But one thing that's often overlooked is the aging process for executors and attorneys themselves. They may include best friends, sisters, brothers, or even parents. Their aging may mean they are no longer well suited to the roles. One possibility for executors and attorneys is always involvement of a professional. This could be an individual or a trust corporation. But great care is needed here. There's sometimes a tendency for law firms who write wills to offer one of their partners as an executor or attorney. That might seem like a good option at the time if the candidates for the roles amongst friends and family don't seem likely to be able to guarantee the relevant qualities and availability when needed. It can, however, come with unintended consequences. A lawyer who's very helpful and understanding when a will or power of attorney is being prepared is unlikely to be someone who will be able to step in and perform the actual roles when the time comes. Legal firms tend to act on a transactional basis, and they don't tend to be equipped to drop everything and intensely manage the wind-up of an estate over a period of 2 or 3 years, or handle someone's financial affairs for perhaps decades. Legal advice can be essential to attorneys and trustees, especially when winding up an estate. But it is generally better for the executors to take that advice rather than having the lawyer who drafted the will or power of attorney amongst their number. There can be a role for a professional executor or attorney for the property and financial power of attorney. This should be a specialist firm rather than an individual, and it should have the resources to step in as and when needed. And an attorney for a health and welfare power of attorney can only be an individual, and clearly the skills and qualities required to oversee someone's physical care and mental well-being are very different from those required by an attorney managing day-to-day bill payments, property and investments. So, there's no necessity for the attorneys under each power of attorney to be the same. What is, however, important is that they know one another and can work together when needed. It's quite likely that incapacity for both purposes will be triggered at the same point. But it's also quite possible that a property and financial attorney might take over with the willing consent of a person who is fully mentally alert, but the health and welfare attorney can only step in when mental capacity fails. When the two sets of attorneys do have to operate together, there will be decisions which affect both of them. Decisions on care homes, care at home, medical treatment. They all usually involve money. The purse strings will be held by the property and financial attorneys. The health and welfare attorneys will need to make sure that they will have the financial support for whatever decisions they wish to take. Very often, broadly the same group of people will be executors and attorneys. If the level of deep thought required about the choice of each were rated out of 10, for executors, it might be a 5 or a 6, but for attorneys, it's probably a 9 or 10, due to the fundamental differences in the potential duration of acting, time commitment, and discretion needing to be exercised, and the difficulty of decisions which will be faced. Time spent on discussion with the potential candidates for these roles and the potential responsibilities are critical. In this podcast, we've considered some of the difficult situations which can face executors and attorneys, but it's worth getting the candidates together and rehearsing some scenarios and seeing how they might feel and act. In doing this, there's no point in being over-optimistic and idealistic. The best outcomes will come from thinking the unthinkable.